All right, everybody. So I want to jump on here this morning and have a little discussion before the live trial starts in about 8 minutes. So this is going to be the only trial we have today. Tilly case does not actually begin until April 1st. I thought it began Friday, and then I confirmed it's going to start tomorrow at 12:30. The Sturmer trial doesn't begin again until tomorrow at 9 a.m. So this will be the only one today. And then we're going to have the trial's going to go till 1 o'clock today, according to what the judge told us on Friday. And then they're going to be switching courtrooms because tomorrow the Karen Reed case starts. So this case is going to get bumped to a smaller courtroom because, as you can see, there's really nobody in the audience. So, anyways, look, what do I want to talk about? Why am I coming on this morning? Because this case, I know there's a lot of you, I've heard it, a lot of people are saying, okay, why is this being tried? What's the reason why this matters? And this one is actually, believe it or not, one of the most interesting ones that we have going on right now. And there's a reason for that. And that's because the allegations that the defense is making and the argument that the defense is making is actually quite an interesting one. What they're arguing and what they're saying is that they're almost arguing a form of jury nullification in a sense. Because what they're arguing is that essentially he was unable to formulate the intent and the malice needed for the top charge. And the way they're going to try to get here, and again, the defense, you heard the one hand defense in the opening. Now that's giving the jury a route to even potentially quit this man completely of all the charges. But I don't think that's what's going to happen. And that's not really what the strategy is for the defense. Because what the strategy here is it is to sully the name and sully the reputation of this lady, turn the jury against her, make the jury feel that this is somebody who was trying to take advantage of this doctor, who was targeting him, who had set him up to take his house, take his cars, was cheating with other men, was using his friends, was doing all these things that were really nasty. And then threw this man out in the middle of, 2020 when, well, we can't talk about it on YouTube or say it, but when everybody was getting sick and they had the virus everywhere. And then coldly tells this guy, baits him into, because again, what the story is right now, what the defense is telling is and what they've brought out through the witnesses is that this guy gives her his house, gives her his car in an attempt to reconcile. And the story they're floating right now is that she or he comes back into the house. He's there. They're having a night. They get into an argument. And she basically then tells him, hey, I'm throwing you out tomorrow. This is a story that they're going to tell. This is a story, I guess, this gentleman, I assume, communicates, because I don't think we're going to hear him testify, because he gives it. There's a statement that's going to come in from the police. And then what they're going to say is that she hits him in the head, and then he goes and with some one-hand maneuver kills her. But here's the thing. What they know is that the problem with that, and the reason why he would not get a complete not guilty in this instance, is because the state is going to bring in medical evidence that's going to say he strangled her. But here's how they're going to counter it. And here's what they're angling towards that. He had a blood alcohol level when they found him in the hotel room the next day. I believe it was 0.224. So now, Massachusetts is an interesting state, because not every state you could make the argument the defense is going to make. In Massachusetts, a mitigating defense in an affirmative defense, the premeditation in malice, is voluntary intoxication. If the defense can prove that he was intoxicated and that even though his hands were around her neck, or one hand was around her neck, and even though it takes a minimum of 3 minutes to strangle someone, which is normally plenty of time for a prosecutor to argue that you could have had the moment to change. Because most of the time, if you're going to argue heat of passion, which is how you get to manslaughter, if there's a moment that you could stop, then that argument goes and you're right into the top level of unaliving and the big M. They're going to argue that he was intoxicated. And as a result, in Massachusetts, it is recognized that if you are intoxicated, then you are intoxicated to such a state, and you do this crime, and there was provocation, which would have been the hit in the head, and the statements, and the cumulative behavior, and the cumulative nature of their relationship leading up to that moment, and the idea that she was doing all these things, they're going to say that at that moment, he's drunk, he's not able to formulate intent, he's not intending to do what he's doing, but he reacts, and he never stops, he never leaves that state of mind of reaction where she hits him and he just, and then she's gone. And at some stage, he comes out of it, realizes, oh my God. Now, what they're going to do is they're going to separate that moment. And then when he realizes, oh my God, what have I done? And then he takes her body. Now, and here's how they're going to try to get away with it. He's a doctor, right? So most of the time, you would have a problem with that because they would say, well, why didn't you call 911? Why didn't you take steps? How could you know that she was dead? Well, he's a doctor. So they're going to say he was able to assess at that moment that she was gone. And then he goes and makes a terrible decision to put her body in the pond. But that's a separate punishable thing. So the thing is this, you might be wondering, okay, well, all right, so he gets convicted of manslaughter. So what does that look like for him? Why would he be worried about, is that still going to result? He's 50 some years old. Is that going to result in the rest of his life in prison? No, it's not. Again, Massachusetts we're talking about. So in Massachusetts, the max sentence for manslaughter is 20 years. But get this, and this is where it gets interesting. In Massachusetts, if you're convicted of manslaughter, there is no minimum sentence. He could get probation. He could get time served. He could get a 5-year sentence. He could get a 10-year sentence. Now, here's the other kicker. Let's say the judge throws the book at him and gives him 20 years. He's only going to serve 10. He's already served 5. So it is very possible that this jury if this jury convicted him of manslaughter, that he would be out sometime within the next, well, it's not possible. He would be out within the next 5 years, even if he gets the worst case scenario, which is a 20-year sentence based on the way time served works and the structure and the fact that there was no weapon used, the fact that there was no firearm used in the crime. So this is a very, like I said, very, very interesting case, because this is a case where a manslaughter conviction, it's not quite a not guilty because he's going to walk away with a felony, and I don't know what his immigration status is or if he would be sent back to Germany or not. But it's a case where it would not result in him spending the rest of his life in prison. He would get out in a relatively quick amount of time. So the stakes are extremely high right now. And what they're going to try to do, like I said, is they're going to try to take advantage of the law in Massachusetts that recognizes that voluntary intoxication is a legal affirmative defense to premeditation and to malice. So that's where we stand on this. Leah T, I don't know if you were in here earlier when I addressed that, but the Cementilli case is coming back tomorrow. They were on a break, and then I guess there were some juror issues the judge had a seminar from Monday to Thursday, and then there were some juror related things. So they took off Friday and they took off today, and they will be back tomorrow at 12:30. So that will be happening tomorrow. So this will be interesting. Well, the thing is, though, Mo Freedom. Here's the thing. I think it's going to be a matter of, the defense thinks that this lady is going to really be portrayed, is really going to come across poorly to this jury, in the sense that they believe, I think, that if this jury understands the full picture here, that they're going to look at her as somebody. And I think they've got a lot of, again, remember, the gentleman that's on the stand right now, they just introduced all these text messages, which is not helpful at all, to where she's having inappropriate conversations with that gentleman. That's why he's so nervous on the witness stand. And there's going to be others. The friend, you could tell, the first lady that was called, she was very aggressive in the sense that she was not avoiding and wanting to avoid the full context of what was happening. So I think that what they're going to do here is they're going to try to put on, and I assume they're going to call the divorce attorney in to talk about some of the issues that were present in the divorce, in the sense that what she got and how she was able to get these things from him. And again, they extracted from the one lady who said, I made a good score. And of course, they say, oh, score means, like I scored a great guy. And the idea here is, well, not quite, because she's dating other men. Remember, she agreed to let him move back in to be in part of that agreement was, and this is the stuff that's going to come out. Part of the agreement was that he could move back in and her name went on the deed. Essentially, she becomes a homeowner, right? And I believe she got the Mercedes, the $150,000 Mercedes. She's dating another man, right? And then there's the message the morning of that says she's a snake and she manipulated us all. And we haven't heard what that is about, what he meant by that. So the point of this case is going to be that there is a lot of really underhanded, dirty, sordid things that apparently this lady was doing. And that she was not in this for love or for him, and that she was more or less trying to get his money. And the question at hand is all right, this gentleman who's been tossed out of his house, she put a restraining order on him. Now, again, we don't know how valid or any of that is. And I guess we'll find out, because the state's going to, I'm sure, present that. Because if the state, to me, the state's case has to be that this gentleman was abusive. So there's a line of just actions and behaviors. I assume we're going to hear more about the background of that restraining order. And it's going to be kind of told in the sense that this was a buildup to this moment. And then the defense is going to say, no, none of that was happening. And she was portraying him this way for the purposes of taking advantage of him and getting his money. I don't know what it will be. But the biggest problem that the defense has, in my opinion, and no, it has not, Rebecca. I agree. It has not gone well for the state. And right now, I don't have the warm and fuzzies in terms of this lady and what I've seen. When I heard about this case, I really was not expecting there to be much to this case, because I'm thinking to myself, okay, this guy is about as dead to rights gotten as you're going to get. And then the case starts to progress, and then I'm listening to these witnesses, and I'm like, wait a minute, there's something wrong. That one lady, I'm like, nah, there's something wrong with the way she's telling this story. She's hiding things, and when she tries to reframe a statement that they have her saying in text messages, which is, man, I made a great score. No, that's not what she didn't mean. She made a great score as and I have a great man. She meant she hit the freaking lottery here, right? She's got a guy who's willing to give her the world, and she's taking it all. 3 kids, moves in, but when you think to yourself, all right, you've just signed your house over to this woman. You've just signed your car over to this woman. He's here. There's alcohol involved. And she, apparently that night, there's a tough conversation. In that conversation, did he discover something? We know he did, because the gentleman that's on the stand, he sent the message to that says she deceived us all. She was a snake. So what does that mean? And these are things, and the reason why these are significant things is because these are things that are done, right? Now, maybe there was planning, and we'll find out. Well, Sandy Ashworth, he killed her, end of story. That's not true. That's not end of story, okay? People, there's always a story behind things. If end of story means there'd be no self-defense case that would ever happen. I'm not saying this is self-defense. I don't think it is. I don't think you can justify self-defense here. But when it comes to trials and it comes to the criminality of the actions, you have to match it up. And the state has to prove beyond a reasonable doubt that this gentleman acted with malice aforethought and acted with premeditation. Well, because Tony, you got to remember the situation that you got to remember the situation he was in. Okay, there's a couple things. Number one, he was not an active practicing doctor at that time. He had been suspended due to Medicare fraud. Okay, so number one, he did not have a job. He did not have income. He was living off of his savings, and he had a house payment. He had, obviously other full expenditures. But one of the things you've got to understand is he was unemployed at the time. Okay. Two, we were in the middle of the big P, if you remember what 2020 was all about. So he's in the middle of all that. So there's not a lot of people that are saying, come live at my house. Everybody's home. Everybody's, sheltering in place and not able to go out. So that's why he was reaching out to his friends saying, can I stay there? In normal times, you might not have a house full of people that are staying there at all at one time. And people are like, no, you can't do that. So he ends up having to go down to Florida. So the situation for him was not good. He was not actively practicing. He was not able to work. And he was trying to find a job. And that's why he was looking at potentially going to Germany. And this lady gets him to hand her over his biggest asset, which was his house. Kate says she was a total gold digger. He was obviously lonely and wanted a relationship. Maybe he started drinking due to feel. Well, exactly. She was. I think that's what the defense is going to try to show here. And when that realization hits him, and when she tells him, and apparently she was a silver-toned woman that could upset him greatly. And I mean, again, remember, look at those inappropriate messages she was giving to the dude that's on the witness stand right now, right? If he were to see that, the idea behind manslaughter now, if he's not drinking and he has a moment to calm down, you don't get to strangle somebody. But the idea here is he's drinking, they're fighting, he gets down on his knees, he's begging her, please don't do what you're about to do. And she hits him across the head and he reacts and goes after her. Now, the thing is, if he was in West Virginia, the alcohol would not mitigate that. But he's in Massachusetts. Massachusetts recognizes the fact that if you are intoxicated voluntarily, you can raise that as a defense to mitigate and eliminate malice and premeditation. You cannot formulate that in those circumstances in Massachusetts. So as a result, the defense just has to show that. Now, the state is going to claim that the intoxication happened, or the massive amount of intoxication. I remember he was like 0.227 or 0.224. He was very intoxicated when they found him. They're going to say that happened afterwards. And if that wasn't present at the time this occurred, and he was able to formulate the ability to realize what he was doing, and again, we haven't heard the police statement yet, but that's going to play a big role in this, because if you're intoxicated to that degree, you should be blacked out, right? Drunk. So you should not remember what you did. So again, this is why I said it's not going to be an easy case, but it's going to be an interesting case. And it's going to be one that I think this jury is going to struggle with a little bit. But I think it's also interesting because what the defense is doing here, and again, this is where we come back to Mo Freedom said, I don't think it's going to be a good strategy to solely the name and victim blame. Well, we're going to find out, because what I think they're really going to push for here is they're going to try to absolutely, and you can see this defense attorney is being very aggressive in doing so. They're going to take a big fat dump on this lady, and they are going to absolutely try to destroy her name.
And what they're going to hope is that this jury is going to be so upset with her that they're not only going to say, you know what, we're so upset, the defense has given us the route to completely acquit him. And that is this magical hand defense that he just reaches up and somehow with one hand, Incredible Hulk style, just like crushes her neck. And it was in self-defense. And if you believe that, if a juror believes that, they could find him not guilty completely. So, and it's really a form of jury nullification. And this is what you're seeing, the positioning. And the real correct way to do jury nullification is exactly what you're seeing this defense attorney do. And that is you give the jury a viable path to a not guilty. And in this case, it's self-defense. You completely destroy the victim. You make them hate her. And then you say, you know what? Hasn't this man suffered enough? He lost his house. He's been 5 years in jail. She did all these things to him. Why don't we just let him off? We'll see if it works. Anyways, court is beginning. Let's jump into the courtroom, guys. I want to give you guys that little brief discussion because I saw a lot of questions in the comments, not understanding why a lot of things and a lot of aspects and how's this working. So I want to give you guys a little precursor on what the laws in Massachusetts are and what the defense is relying upon in this case to launch this defense. So hopefully this gives you guys a little more perspective as we continue to listen to this friend and see whatever the next steps are that the state are going to present. And today, remember, guys, 1 o'clock, that's when this thing will end. And then we will be offline for live trials today until tomorrow. And we will be back with all three. Actually, we'll have 4 trials. Kate, the rapper Kate is on trial in Texas. We're going to be bringing you that one. So there will be 4 trials going on tomorrow. So be ready for that. Anyways, let's head into the courtroom, guys. Appreciate all of you. Hit the like button, share this stream to help bring attention to the case. And I'll talk to you guys soon.
Commonwealth versus Ingolf Tuerk, 20 CR 138. The parties are present. The jury is not present. The matter is on for trial.
Good morning.
Good morning, Your Honor.
All right, so I'm told that all the jurors are in. Did you want to address something, Ms. Beatty?
Yes, please.
Yes.
I'm objecting to the defendant continuing to cross-examine this witness regarding text messages. This witness testified on direct examination to nothing that was particularly opinionated or descriptive regarding the victim or the defendant. He was the recipient of a text message that started the investigation. The defendant is not challenging that he sent this text message, it appears, to the Commonwealth at this point in time, and has already elicited many text conversations regarding communications of a sexual nature, the defendant wanting an annulment, requesting communications when the defendant is not around. And I would suggest that all of this serves only to disparage the victim and to potentially lead to some sort of a nullification regarding the manslaughter that was raised in the opening. It's cumulative at this point, and I would suggest that this line of questioning should end at this point in time.
I don't show any surprise over the government's requesting that you shut me down at this point, cross-examining this witness. And my suggestion to the court, and I speak to you as a former trial attorney, you know and you're well familiar with the fact that when you cross-examine a witness, especially a hostile witness, especially a witness that is called for the other side, and you're cross-examining that person, it's almost like, making candy, if you will. There's a time when the candy starts to solidify. You've got to pour it into you know where you're going with your questioning. For them to suggest right now that I'm shut down in front of this jury and sit down like a dunce and just say, okay, I have no further questions, I think is, number one, extremely prejudicial to the defendant. Number two, The government has no idea where I'm going with this. Number three, this guy was well up to here with his discussions with McLean as to the settlements. What should I do? He won't settle. Fannin-Steele says, oh, I'll talk to him. Let me talk to him. There are significant discussions back and forth with his state of mind, Fannin-Steele's state of mind, talking about the pandemic, statements that are made by Dr. Tuerk as to his fear and concerns about the pandemic, not just, can I stay with you? All of these things are all legitimate questions. And you know, I'm towards the end, obviously, of my cross, so I would take a significant objection to being told I can't cross-examine this witness.
So just to be clear, I don't think it's the cross-examination in general, correct?
No, it's this line of questioning. I would suggest that statements of the pandemic are very different than the line of questioning that's been, you know, there may be other objections to that, but and statements regarding reconciliation and Mr. Fannin-Steele mediating between the parties, that's also a different line of questioning.
Okay. So to the extent the cross-examination goes to the victim's state of mind, which we already talked about, that would be permissible. And to the extent it goes to any bias on behalf of this witness, meaning his relationship with Ms. McLean, that's also permissible. However, I think you've already established that he had a close relationship with Ms. McLean, so any further questioning about specific texts with respect to...
I caution the court, with all due respect, not to shut me down on the texts between this witness and Ms. McLean, because it goes to the heart of the cross-examination, and he has a right to confront the witness. I know the government is not happy with the way the witness has stood up, if you will, but to suggest that I have to now, in front of this jury, have no further questions regarding text where you know that I am ready to go on that with a fairly short balance to finish off my cross-examination, Your Honor, I would significantly object to being shut down in that regard. I understand your concern. I have a couple of other questions that I'd like to ask this individual, but I ask that the court not close down, if you will, cross-examination.
Again, to be clear, my objection is not to questions regarding text messages. My objection is only to text messages regarding what Mr. Reddington characterized at sidebar was an inappropriate relationship between the victim and himself.
Well, it is an inappropriate relationship, and there's...
So I will take it question by question. Your objection is noted. I think you've established, with respect to the inappropriate messages back and forth, that's been established.
I understand that, yep.
Okay. Anything else?
Nope.
Thank you.
All right. And who do you have after this witness?
Officer Ellis.
Okay. All right. And before I bring the jurors in, you prepared to go a full day or almost a full day tomorrow?
Yes.
Yes.
Okay.
And if Wednesday is possible also, we could talk about that tomorrow.
All right. We'll check on Wednesday. We are moving courtrooms tomorrow. So we'll end at 1 o'clock today.
Thank you.
Okay?
We're going in the small courtroom?
We
tomorrow?
are. Okay. All right. I'll step off and we'll bring the jurors in.
All rise. You may be seated.
New locking system. It's very, very nice.
what was a risk, so you can get out. Because you could do 6 months. It's a good 6 months, but you can not. It wouldn't kill. It would be enough.